Will the court consider that my ex is a narcissist in deciding custody? Hi, I'm Bill Farias, founder of Farias Family Law, and this is a question that we got just a couple of weeks ago, but we get this question at least once a month. We have people who come to us who are dealing with exes or soon-to-be exes that are very difficult, and they refer to these people as narcissists and are wondering whether the court is going to take into consideration these personality issues in deciding custody. And so, first of all, understand that there is a wide spectrum of narcissistic behavior, right? You have someone who may exhibit a sign or two, or a behavior or two that is consistent with narcissistic personality disorder. And then on the other end of the spectrum, you have a clinically diagnosed full-blown narcissist and everything in between. So the term narcissist is thrown around a lot in describing people who can be self-centered, difficult, grandiose, lack empathy. And so it's important to understand that people fall anywhere on this huge spectrum, and you have to be careful about labeling somebody a narcissist when you see just some of the tendencies. But the bottom line is that in determining a fair custody arrangement and in determining what's in the best interest of the children, the court will consider any behavior by either parent that is detrimental or against the well-being of the children. So if it's behavior that clearly negatively impacts the children and there is evidence of that negative impact, then certainly that's something that the court will take into consideration. But I feel like for the most part, people have unrealistic expectations in terms of how heavily a court is going to weigh somebody's personality deficiencies. And sometimes it's because that person can be very difficult to a spouse or soon-to-be ex, but in other situations and in other relationships, that type of behavior isn't as visible or prevalent. And so the bottom line is, if you feel like this personality defect or issue is negatively impacting the children, you have to write down and gather evidence of exactly what that negative impact consists of. What is this person doing? How is it impacting the children? How have you seen it impact the children? What is the evidence of impact on the children? Are there third parties who are complaining about it? And so the best way to approach this is to get this all down and talk to an experienced and trusted family law attorney who can look over all of this information and let you know whether this is really going to make a difference, right? Because you have to choose your battles carefully. And so before launching into a representation before a judge about certain issues with the other parent, you want to make sure that you have a good enough chance that this is actually going to matter, right? Because otherwise you're wasting the court's time and you are diluting your argument and possibly hurting yourself in the sense that other issues that might actually matter and have an impact on the hearing are being left out to add these complaints about somebody's personality or character. So does it make a difference? Maybe. It depends on the connection between this person's issues, the personality issues, and the impact on the children. And so the best thing to do is get this all on paper, think about the evidence you have, get it assessed by an experienced attorney, and then you can determine together whether that's information that would be useful in a custody proceeding. If you have any other questions, you can call us at 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on Instagram and Facebook at Farias Family Law. Thank you. Have a good day.